Hello and welcome to the American Experiment podcast. I'm David Zimmer, the Public Safety Policy Fellow with Center of the American Experiment, and joining me today is Chris Madel, noted attorney, and involved in what I would probably call one of the more consequential wins in public safety this year, the successful defense of Trooper Ryan Londregan.
Thank you.
So we're going to get into that case and see where our discussion takes us over the next half hour or 45 minutes. But before we start, as a former law enforcement officer, retired, and as the father of a current law enforcement officer, I want to just thank you for helping start that pendulum swinging back to somewhere more in the middle here. We've been in the midst of this anti-police environment over the last 4 or 5 years, and it was just so refreshing to see you come out with a spirited defense. I was reminded, I believe it was the day of the charges being announced, and you kind of boldly said something to the effect of the anti-law enforcement movement needs to end, and it's going to end with this case. So anyway, thank you for that spirited defense, and it's much appreciated.
Well, thanks, Dave. But I'd appreciate it if you wouldn't begin the podcast by making me tear up, because one of the things that's honestly been really difficult for me in the last week, ever since the publicity of the charges being dismissed, I've received over 100 email, voicemails to the firm, phone calls. I've received one negative email. The emails that I've received have been heartbreaking, is probably the best word, from current and former law enforcement, parents of law enforcement, wives of law enforcement, kids of law enforcement. And it's just so difficult for me to read the thank you. First of all, I'm not very good at taking compliments, put that aside, but just the sentiment that people have of saying somebody's standing up for law enforcement, I just hate it, because it just shouldn't be like this. I grew up, we played cops and robbers, and the cops were the good guys and the robbers were the bad guys.
Right.
And we ran, and I was raised from the idea that those men and women in blue were the people that you went to when you most needed help. And the notion now that people are just, my God, thank you for supporting us, it just tells me that we've just really lost our way. And it just hurts, honestly.
It is a sad statement, or a sad truth, but it is where we are today, and your defense in this case was remarkable and is deserving of thanks from the law enforcement community. So thank you. So there's so many details in this case over the last year, and I really want to dig into them as best we can. But what I'd like to do is start with maybe learning more about you, and then learning more about Ryan, the person. I found it intriguing in your press conference Monday. You spent a fair amount of time telling the public who Ryan, the person, was. And that's special. That gets lost in these cases. Anytime a police officer is accused of anything, all it is, you look at the person, or the public seems to look at the person as a uniform. They dehumanize him. And I think it's really important, especially now that he's been cleared of this wrongdoing, that we learn more about Ryan, the person. But let's start with you. How did you get involved in this case? You're a defense attorney. Probably have never defended an officer before in this kind of case.
I have. I defended a Minneapolis police officer who was charged with some conduct off the job when he actually arrested some kids.
Okay.
And was charged with felony false imprisonment of children, interference with a 911 call, and disorderly conduct. The jury came back in that case in less than 15 minutes. Total acquittal. And it was another, frankly, just insane case. That was another case. This was a Medal of Valor winner. I have never had a trial where I literally felt that the jury was leaning forward, wanted to hear more stories from my client over and over again about everything that he had done. And he was so remarkably modest. And he actually got mad at me on the stand for bringing up some of his accomplishments. And I actually promised him on one story that I wouldn't bring up in court. And then he said, you weren't going to bring it up. And I said, yeah, I lied.
Yeah.
And but he was just a phenomenal, great police officer. But again, another casualty of our times. He retired early and took a private sector job. It's a notable private sector job now because of what we're talking about today.
Yeah.
Just lack of, and this was prior to 2020. He just, so many people, questioning everything that he's doing. He literally was on Block E and saw a man holding a firearm right next to his side, and he disarmed him without taking his own gun out. And I said, why didn't you take your gun out? And he said, too much paperwork, too many questions. But I mean, I did the exact same left, but then I kind of thought twice, like, my God.
Yeah.
This man is in the moment is thinking about not pulling his own gun in order to get the bad guy because he's worried about, frankly, jackasses coming in later on and saying, what did you do? Why would you do such a thing? And all that nonsense. So why did I get involved in this? Sorry, answer your question more directly. It began, there was a lot of concern over the three officers that accompanied Chauvin that day,
Yep.
in which I continue to believe to this day are innocent. I can openly say, when you look back on something that with that 2020 hindsight, you can look at people like that and say, I wish you would have done something different in the moment. My God, how many times have there been in my life where I look back on something? It's just that my actions don't have these amazing consequences that law enforcement have and the responsibility that we put on all of your shoulders.
Sure.
And then expect perfection all the time, perfection every day. Then when Kim Potter happened, on that case, I offered the resources of my firm for free. That didn't work out. Then at that point, Brian Peters met me along with Stephen Furch, Stephen's an outside lawyer representing the MPPOA, both just fantastic, courageous people, asked me to join, and I said, absolutely. And it really has been an honor. And but as I've kind of alluded to here, Dave, that it's been difficult to kind of get this kind of adulation for something that I think I'm just doing what any lawyer is doing the right thing. And this is something where I honestly feel like I am promoting not only with respect to law enforcement, getting a better name, but with respect to somebody like in Ryan's position who is truly innocent and had no business whatsoever being charged with anything. And I will believe to this day, and I continue to believe to this day, that he's a hero.
Yeah. Yeah. Well, I can see, I'm sitting 2 feet from you and I can see the emotion in your eyes. And it's impressive to see.
Well,
impressive to see.
Thank you. But, there are some people who say maybe it's a bit much, so I apologize for that. But I obviously feel very strongly about this. I really sincerely believe that we, as a community, as a Minnesota community, and let's go outside of Hennepin County, just as Minnesotans, we've lost our way.
Yeah.
And it needs to come back. And it needs to come back with leadership from the top all the way down through the ranks. And we need to bring this back by exalting what our first responders do.
Right.
As I've said before, and I say it often, there is no chance that I want to do that job. And every time that I still watched, and the amount of times that I watched these videos of Ryan pulling somebody over in the dark of night, you can't see anything in a car, it just scared the hell out of me.
It is a tough, thankless job, I can tell you. And,
it is.
Yeah. So, you joined the panel. Is that it? The panel being a panel of defense attorneys that have agreed to defend law enforcement.
Correct.
For the Minnesota Police and Peace Officers Association.
Correct.
Is that right?
Yes.
And the funding for that, I think there's a lot of, almost misinformation out there as if the state is funding this. The funding comes from officers themselves, right? Through
Yes.
the Legal Defense Fund. Can you explain that a little bit more?
Yeah, and this is, Brian Peters is going to be better than I to explain this, but I'll tell you my understanding of it. There are a number of police unions throughout the state that contribute to the MPPOA Legal Defense Fund. I'm going to go back on my soapbox here for a second. The hourly rate that you receive from the MPPOA for me is about a fourth of my normal hourly rate. So it's not like it's a big money maker for me.
Right.
The thing that really just annoys the hell out of me, though, is that if I'm representing you here at the center and you are charged with, let's say, committing some crime on the job,
Yep.
and then I represent you, I get to the end of that case and you're acquitted, you have under statute the right to seek indemnification from the center and have the center pay me legal fees at my standard hourly rate. I can't overcharge them, and a judge can pass on my fees and say whether or not they're unreasonable or not. The same thing is true with all Minnesota employees with respect to Minnesota entities, and there's a statute specifically that provides for this indemnification. And for Minnesota entities, the statute actually says even if you're convicted, if you can show that you acted in good faith, you're still paid with respect to that. Police officers?
Doesn't happen.
Nope. MPPOA is going to pay that, and let's just hope that they don't run out of money.
Right.
And even though Ryan won, MPPOA is left holding the bag. Now, I'm going to try to change that because I think that the law needs to change with respect to that, and I think that there's different avenues in order to explore that. But the very fact that that isn't just obvious to me is just wrong.
Yeah. Well, tell us more about Ryan the person. Who is Ryan Londregan?
So when you're just talking about that, I'm just going to think about my most recent conversation with Ryan. Jenny and I had lunch with a friend of ours today, and Ryan was in my office this morning, and we're going through some stuff on the civil matter. And I asked Ryan if he wanted to come along for lunch, and he couldn't because there was a leak in his home bathroom, and he had torn out the sheetrock, and he was tearing out the tile in order to kind of get at it, and he was inviting a trooper friend of his to come over and help him out. Which one of us has that not happened to at one point or another?
Right.
And to get to your point, which I think is a really important one to make, it has become this, that when a law enforcement officer gets charged, you see that uniform and the badge. The one thing I'd add to your statement, more important than anything to the public, a gun.
Yeah.
You have a gun, and therefore, everything changes because you have this gun. Well, they have a gun for a damn good reason. There's a lot of bad people in the world, and, they are there, again, to really protect us. But Ryan goes home to Grace, who he met in 6th grade, which still freaks me out because I remember my 6th grade girlfriend, and I do not want to be married to her. But they've been together this entire time. I mean, I even asked him, I said, was there any time that you guys broke up? And he said, no. They've been together all forever.
Yep.
They have a 1-year-old who just turned 1 in May. And Grace, I was talking to her in the last week. She has now lowered the amount of children that she wants to have from 6 to 5, which I also told her, having 2 daughters myself, that seems like a terrible amount. But they're just great people. These are people that I would be proud to have as my neighbors. I'm certainly proud to have them as my friends. And they're honorable. They're people with integrity. They're fun to talk to. One other thing that I'll just add about Ryan. The Ryan that I knew before Monday and the Ryan that I've known since Monday are just remarkably different people. the utter relief that you see on his face. I had a conference call in his case, and he was in my office and was listening to it. And I looked over at him during the course of the conference call, and he was just sitting there smiling. And I'd never seen that. I hadn't seen him I made jokes where he would smile and laugh, but I hadn't seen this just abject relief and just peace in his face. And he is just it's getting better all the time, but he's just the real Ryan, I think, for me at least, because I've just met him after this horrible incident happened, is just really being revealed to me on a day-by-day basis. And honestly, and I hope he's not listening, because I hate, as he well knows, I hate complimenting him to his face, but it's just beautiful.
Yeah.
It really is. It's just beautiful to see the person like this, and without these charges hanging over his head.
You can just imagine the weight that was lifted when he heard the news, right? So what kind of an officer was Ryan Londregan, or trooper? And the reason I ask is, in the statute, the defense is, what would a reasonable officer do under these circumstances? Was Ryan Londregan a reasonable officer?
Oh, for God's sakes. I mean, yes. And I mean, he not only has won the Mothers Against Drunk Driving award, he won the Rookie of the Year award. He, even in the final year of 2023, in those 4 months that he was working, he had already won the Bronze Award from the Mothers Against Drunk Driving for DUI arrests, for the number of DUI arrests that he had had.
In 4 months.
Yeah, in 4 months, he won the Bronze Award. I mean, he was top, in the state with respect to DUI arrests, right out of the blocks. I mean, he graduated with a 3.83 GPA from college. I mean, this is not just somebody that is just, I have nothing else to do but go into law enforcement. He was doing really well at college, and he said, this is how I want to give back. And he was just excelling at it and just doing phenomenally well.
Correct me if I'm wrong, if the timeline is right in my head, he made that choice post George Floyd, right?
Yes.
He chose to go into law enforcement post George Floyd.
Thank you, Dave. Yes. He actually applied, and then once COVID hit, he had to reapply because they shut everything down.
Right.
So he waited around and worked, did some side jobs as a private investigator for a while because he was waiting to get into the state patrol.
Yeah.
And where, again, somebody like him, and his father is successful in business, somebody like Ryan, he could have easily, very quickly been pulling down a 6-figure job. Easily been pulling down that.
Right.
And just not interested. He really just, his whole idea of wanting to give into law enforcement, and this is not a law enforcement family. And like
right.
My family, I'm the only lawyer. Everybody kind of looks at me like I'm crazy, like, why do you want to do that? It's the same sort of thing with Ryan. His mom and dad, over and over, just like, this is how he's been since day one, that he wants to give back.
Sure. And thankfully, young people like that still exist and
God.
are getting into this profession.
I mean, honestly, were they not, it would just be shocking. Last night was at the Center's dinner, as you were.
Yep.
And heard the former Prime Minister of Israel talk about the TikTok generation and how they were worried that the younger people were not stepping up. And then after October 7, found out, thankfully, that they were. I really feel that that's true here too. Yep. I really honestly do. I feel like there is an entire generation out there that is yearning to give back to public service. And the problem is, particularly within Hennepin County, I would argue, in a lot of ways, the logical thing to do, be a law enforcement officer someplace else, because you don't want to risk that. In fact, I've received emails from men and women who have said that they quit their jobs because they had to have a conversation with their spouse and said, what happens when you have to pull your gun? And what happens if you get charged with respect to that? They have a stay-at-home husband or stay-at-home wife and kids. What happens?
Yeah.
It's got to stop. It's just got to stop.
Yep. So we know a little bit about you. We know about Ryan. Now let's talk about Ricky Cobb. What can you tell us about Ricky Cobb and the life he led?
I mean, I could bring one of the pieces that we got in discovery was his FBI sheet, and it's thick. And the most notable things, though, for me that really kind of stood out were the felony conviction of domestic strangulation and these orders for protection. And what I keep hearing over and over, is how tragic and sad this is. I would agree in one respect. It's tragic and sad that he just didn't follow the lawful orders and get out of the car, and I wouldn't be speaking to you today.
Yes.
And Ryan wouldn't have been charged. Trooper Seide never would have been placed on administrative leave, and all of that. That's where the tragedy and the sadness with respect to Ricky Cobb in my world end. He had a firearm in the back of the car. It was on the center console. When I heard the county attorney at her press conference say that was irrelevant, my managing partner can attest to this. I screamed at my television set. I'm not going to repeat what I said, but it started with a B and it ended with a T, because that to me was the reason that Ricky Cobb took off. Because when Ryan opened that car door, he knew that he was a felon in possession of a firearm, which is a felony in and of itself. And he was not going to let somebody find that. I believe that he had already hidden that firearm. And the very fact, too, and I know we'll kind of get to this, but with respect to as him reaching for Ryan's gun on top of that, shows, again, his familiarity with that. Also, last point I'll make, with respect to Trooper Seide made 15 various times to try to get him out of the car. 15, okay? I was looking forward to trial and asking whomever their expert was, putting up that video and saying after the first time, would it be reasonable to have this person comply? Okay, how about the second time? How about the third? How about the fourth? The fifth, maybe? 6, 7, 8, 9, 10, 11, 12, 13, 14 now? How about, okay, so 15. So how many times, because there's this narrative that's going out there right now that they didn't try hard enough in order to get Ricky Cobb out of the car. What's the thing that he said back to Trooper Seide immediately when he told him that there was something with Ramsey County? He said the name of the person that was the subject of the order for protection, and then he said, every time you all try to get me out of my car, you arrest me, but now for what?
Right.
Now, I can tell you, I'm 57. I've been pulled over before. I have not been asked to get out of the car yet. But if I were asked to get out of the car, I can tell you that the thing that I tell the officer is not every time that you tell me to get out of this car, I get arrested. It hasn't happened to me.
Right.
So that demonstrates a lot who this person is. You add that together, and again, he's got a gang tattoo of one of the most notorious gangs from North Minneapolis on his calf.
Right.
I mean, are we, and now we're going to give this guy sainthood? I mean, it is just outrageous to me what this narrative that comes out of the Hennepin County Attorney's Office has been, and the criticism of the defense when we try to point it out.
Right.
Which, I mean, it's astonishing to me.
I think the point you made that his mindset it was so clear. His mindset was, if they pull me out of this car, I'm going back to prison. So he was never going to cooperate with them. And like you said, they gave him 15 opportunities. A 16th was not going to help. And it's almost offensive to read the steptoe summation of the case, where they're blaming Londregan for like pushing the envelope by unlocking the door and opening the door after minutes of asking the guy to get out.
I mean, are we really expecting anything else from steptoe that were hired by Mary Moriarty?
Right.
$850 an hour, reported by outlets that nobody else in the office would work on the case. Are we really, surprised that they're going to come out in favor of what Mary Moriarty has said? Now, but let's also remember, though, too, on January 24, when she gave her press conference, she talked about how extensive that the State Patrol training was.
Right.
And now suddenly, oh, geez, this State Patrol training's horrible. I mean, it's just, you literally have to check the wind that day to see which way that the truth is going to flow out of this person's mouth.
Right. Well, let's we've kind of dipped into some of the facts, and for somebody that doesn't know anything about the case, it might be a little confusing. So let's go back to July 31st, 2023. It's 2:00 a.m. in the middle of the morning, or middle of the night, on I-94 in North Minneapolis, a busy freeway. Even at that time of night, you have drunks out on the road. And I'll just lead into it. Trooper Seide, as I understand, sees a vehicle driving down the road with the lights off.
Yep.
So he effects a traffic stop. It identifies the driver, only occupant, as Ricky Cobb, learns that he has this warrant, not a warrant, but a want. It's probable cause to arrest Ricky Cobb, stemming from a violation of a no contact order in Ramsey County. So with that as a lead up, what does Seide do, and how does Londregan end up on the scene, and what plays out there?
So as Seide is approaching, he puts in his plate into his CAD, which is the computer-aided dispatch. And I just want to say for your listeners, I've just learned all of these acronyms as a part of this case. So if I sound cooler than I am, believe me, I'm not cool. So he puts that in, and what comes out is this automated message that says order for protection, and because Cobb's name was associated with that car. What happens then with respect to dispatch, which they refer to, you'll hear on the radio, is referred to as Metro. Metro then says, and Trooper Seide's badge number, I want to be careful to him. Let's just call his badge number 101. They'll say Metro 101. And then he then responded, Metro 101 copy. That is essentially code for them that says you have a critical hit, meaning that you have somebody there that has hit on a cops alert that is an important one. It could be an order for protection. It could be that this person frequently gets into some sort of fights with law enforcement. It could be a whole variety of things. But one of the things, the reasons that Metro does that is they want to make sure that the trooper saw that critical hit.
Okay.
When that comes across the radio, Ryan is doing a field sobriety test of another person that interestingly had another critical hit that said that this was a known terrorist member. Yeah. And that came across on the audio. You can literally see Ryan when comes across the radio, it says Seide's badge number and Metro. Ryan reaches down to his radio and turns it up. When other troopers hear that, you hear that on my squad, Dave, you're driving at night, you come and help me out. You want to make sure that I'm safe.
Right.
Erickson heard it too, and he went up in order to help Seide. He was there next to Seide first. Ryan gets done with his potential DUI. This person blew .06 and passed their field sobriety test. And Ryan said, you're free to go, and sent him on his way. Ryan then takes off to go towards the scene. In his squad video, you can see Seide pulled over. You can see the lights pulled over. As Ryan's approaching, he comes up behind another car that's going 80 miles an hour. He pulls him over. Ryan pulled him over because he was worried that he was driving so fast, he was coming up on Seide and Erickson, that he might hurt them. He knew that he had a critical hit, but he saw that as more important in that moment. Yeah. So he pulls him over, and it's a young African-American man, and he's scared out of his wits that he's being pulled over by the police, because this is the thing that's frankly being drilled into everybody nowadays.
Right.
And Ryan then says, it's all good. It's all good. He runs the guy's license. You could see on his CAD that he had some previous infractions, but he gives him a warning. And he tells him, drive safe, have a good night. It's the last thing he tells the guy. He said, you don't need to pay anything. You're gone.
Right.
Now, I'll tell you one other thing. I haven't told anybody. This was a young African-American man that minutes before Ryan showed up on the scene with Cobb. And he gave him a warning. As a defense lawyer, I saw, well, that's great. This is dynamite stuff, because I see my client pulling over an African-American person and cutting him a break and letting him go.
Yep.
If he's this huge racist, he's just going to, belittle the guy, yell at him, the big bad cop, and here he is giving him a warning and going.
Right.
When I brought this up with Ryan, I said, this is fantastic. Why didn't you tell me this? Why?
Happens all the time.
He didn't even understand why this was good for his case.
Right.
The absence of racism from this man, he didn't even get
Sure.
in that moment why that was necessarily good for any of this. It's totally relevant because he pulled him over because he was trying to protect Seide and Erickson, and you could literally see the cars in the distance, but he didn't even get it.
Right.
So he drives up, comes up on the scene. First thing that Seide says is, hold tight. Ryan's like, what? And then Seide starts telling Ryan he's amped, he's a little edgy, and he just seemed to be, generally the tone that he was kind of giving him is that he was non-compliant. And Ryan just sat there. Erickson then tells, Seide is now waiting for Ramsey County on the cops alert that came up on the order for protection to call him back and say what they wanted. Now, Seide could have just ignored that and just arrested him, but Seide wanted to hear from Ramsey County, do you really still want this person?
Right. Typically, you would confirm that they want him. Yeah.
Again, you know this better than I did.
Yeah.
So, but it's. I also thought that was notable, that they didn't just jump on this person from
Right.
North Minneapolis that was coming straight after bar closing at 2 a.m. and say, we're going to take you in because I can. They confirmed with Ramsey County. That's the reason that the traffic stop took so long. It took forever for Ramsey County to call Seide back.
Sure.
So in the meantime, Seide asked Erickson to go up to the car and just kind of talk to him and maybe kind of de-escalate it a little bit. Erickson comes back and tells Ryan, I think he kind of likes me more than Brett, Seide. And they kind of laugh about that a little bit. Seide doesn't hear it because he's talking to somebody else in his car. Ramsey County calls, says, we want him arrested. Seide gets out of his car, and Ryan sees him get out of his car. So Ryan gets out. Seide says they want him hooked up, which apparently is your guys' term for want him arrested.
Right.
And then he said, I'm going to do a driver's side approach. Now, what happened at that moment, too, is incredibly illuminating. Ryan then said to Seide, he likes Brett. The reason he said that to him is because Brett just told him he likes me more than he likes Seide. So Ryan was suggesting to Seide maybe Brett should be the one that goes and does the driver's side approach. Seide's response was, oh no, he likes me too. He's nice to me too. Ryan's like, okay, it's your stop.
Right.
I'm just here to protect you.
Well, one thing I've heard Moriarty talk about is that these three troopers on the side of the road did no discussion, no planning, no discussion on how to affect this arrest. It sounds like they did quite a bit, and I'm guessing there's more. I read in the complaint, in her own complaint, she talks about they discussed the idea of putting stop strips in front of the tires. But at her press conference, all that went out the window, and she's alleging they did no planning at all, went up haphazardly, and got in this shooting.
Yeah, a couple things about that. First, let me hit the stop sticks. That conversation occurred before Ryan got there. If it had occurred when Ryan was there, Ryan experienced a situation where the Ramsey County Sheriff's Office, and I apologize to whoever the deputy is here, but the deputy didn't get the stop sticks out of the way fast enough as Ryan was pursuing somebody.
And he ended up with some flat tires.
He went over 100 miles an hour over some stop sticks, and he continued to drive, he estimates, for approximately 30 seconds.
Yeah.
So the notion that these stop sticks are just like the end all be all, like, oh my goodness, it's just going to stop Ricky Cobb here on a dime, that's just stupid. I mean, you can say, it's silly or something like that. It's stupid, okay? It's just dumb. Because if you actually go to the Stop Six website, as I have, and you go to their training video, they say on the average passenger car, it takes 20 to 30 seconds to deflate a tire.
Right.
One of the things I was looking forward to asking somebody, hey, I park in ramp A. Would you like me to drag you for 20 or 30 seconds down I-394? Is that okay? Let's go.
Yeah.
I'll go to the bottom of ramp A. You put your arm in a seatbelt, and I'll take off here for 20 or 30 seconds, and we'll see how it turns out. How's that sound? I mean, it's ridiculous. I mean, it is literally ridiculous. And I think what they're trying to kind of equate stop sticks with are these terrorist barriers around United States embassies. Okay. And they're just not the same.
No.
Now, with respect to what you're talking about, how that they never had any discussion. And again, Dave, you know this 100 times better than I. The amount of training that you all receive and the drills that you receive over and over and over again, it is similar to what happens in the military. You can have a look or a hand gesture that more or less recounts weeks of training with respect to that very event. It's no different than if I talk to one of the lawyers in my firm and say, let's file a 12B6 motion on this. Okay, yeah, I said that in less than 5 seconds. That is recounting 32 years of experience, including law school and including the law school of the person that I'm speaking to. So it's not like you guys can have a little conference. Let's have a fold-out conference room in front of your squad car here, sit down and have a little meeting with a PowerPoint presentation as to how we're going to approach this car.
Right. It wasn't a complicated arrest. No, it really wasn't.
No, it really wasn't, honestly. No. Yes. No. And you had 3 officers there.
Right. And going back to what you've said a couple of times now, it all could have been prevented by cooperation on Mr. Cobb's part.
In a heartbeat.
Right. So they go up. Ultimately, he refuses to get out of the car, refuses to turn the car off, hand the keys over, just really won't cooperate with anything. At some point, I don't know who would not find this reasonable. At some point, the police officers need to go what we always called hands-on. They have to put hands on somebody and try to effect an arrest. They tried for several minutes to verbally talk Cobb into that, and he refused. So Londregan unlocks the passenger door, and I've written about this. What he was doing, what I saw he was doing, I didn't think he was going in to make the arrest. He was going in to provide armed cover for Seide, who was making the arrest.
Well, that's because you have a brain, Dave.
Okay.
All right. So, and you obviously are not going to be getting a job at the Hennepin County Attorney's Office anytime soon.
Right.
Because, you actually know how these things work. And I've certainly learned how it works, not only from talking to you, but talking to actual use of force experts that have done this and have schooled on it for this long. One of the additional things, too, that Ryan would talk about is that by simply opening up a car door, a lot of times, people will argue, and then you open up the car door and they go, okay, all right, we're done. Okay, I get it. I'm getting out right now. But again, now we're coming back, though, to the difficulty with the job overall. The unpredictability with respect to what you had to deal with as a police officer is unlike anything, when I've certainly had a lot of unpredictable things happen on this case. The worst thing that could happen to me are paper cuts, or perhaps somebody, opened up my Diet Coke too early and it was flat. I'm certainly not dealing with the unpredictability that there is a loaded firearm in the back and that my partner or I are going to be killed.
Right.
And that is the thing that I just don't understand with respect to these sorts of charging decisions, that's every stop that you guys have to deal with.
Yeah.
You just don't know when this is going to happen. And God, how scary is that? I mean, it's the same thing that they tell you in Hollywood, that the scariest things are always off the screen. Everything is off the screen with you guys.
Right. Going back to the step-toe summary, they were highly critical of the tactics used by these officers, and I found that offensive too. They don't offer what tactics they should have used. They just are critical of the tactics they used. Again, there is no way to physically arrest Ricky Cobb without eventually opening those doors, attempting to get the seatbelt off him, and physically pulling him out of the car. And that's what these troopers attempted to do at the time he made a conscious decision to put the car in gear and drive forward with two of them partially in the car, putting them at risk.
But you're missing the point. The point from them, they should have done nothing.
Right.
They should have just let him go.
Which is an absurd option with a violent crime.
And with a person that has now figured out the reason that he's about to be arrested.
Right.
And he's going north on 94, which can take you right up to 694, which can take you right over to St. Paul.
Yep.
And as I've said before, I just can't fathom if he would have hurt that person, who, by the way, is one of the people that shows up to every press conference talking about poor Ricky Cobb. But if that person got hurt, what would have happened to Londregan, Seide, and Erickson? Like, how could you possibly have let this man go? My God, he was domestic strangulation. He was wanted for an felony order for protection.
Right.
How could you have done this? And he had a gun in the car. Then, believe me, then it would have been relevant.
Right. So after the shooting and Ricky Cobb's death, let's kind of jump forward. The BCA gets involved, and what can you tell us about why the BCA investigates these cases?
Well, and again, this is before my time, but apparently now the BCA now takes over all officer-involved shootings. They actually have a unit that's involved with these things, and they are in a lot of ways a very difficult position with respect to these things, because a lot of them are former cops themselves. And I happen to know, in this case in particular, that the BCA largely did not want charges being brought here. They didn't think it was fair. So they're really kind of put in a possible position, especially when they're put in with somebody with the likes of Mary Moriarty. But they investigated. They ultimately turned over the entire file. They were very careful to say that they made no independent judgments with respect to whether or not he should be charged or not. That is one of the systemic things, though, that I really wish would change in the future. The very fact that I, as a prosecutor, am asking you as a police officer to sign a criminal complaint that you don't believe in, I want BCA and, frankly, all law enforcement officers to know you don't have to sign that if you don't want to. You don't have to put your pen on that paper if you don't believe in it. You can say no. And as a legal matter, you can do that. And certainly, Mary Moriarty can't fire somebody at BCA. And I'm hoping that in the future, BCA kind of recognizes that more here, because they got to recognize the power that they have.
They have some power in
yes,
that
they
decision.
Do. They do.
Yeah, that's a good point. Good point. Yeah, it's just so the listeners understand, the county attorneys draw up and actually type up the complaint in the officer's name, and then the officer signs it. So, if I understand correctly, the BCA investigated for about 2 months, turned over the case to Mary Moriarty. She had hired, interestingly enough, in August, a expert in police use of deadly force. And what did she say about the critical nature of that expert?
She said during her very first press conference that they had already retained a use of force expert, and that use of force expert's opinion was critical to the process. That person turned out to be Jeff Noble. Yep. And they gave him a bunch of documents, excerpts of videos. And in, I believe it was October 13, 2023, he then had a conference call with Mary Moriarty, the lead prosecutor, Mark Osler, and others, where he told them, I think that what Londregan did here was reasonable because he could say that he was acting to protect Trooper Sighty. Now, let me stop there. The notion that, well, Londregan didn't say this to anybody. I mean, really, do you have a brain?
Right.
I mean, can you see what he's doing here? Are you honestly believing that if Ryan Londregan came and said, well, I was protecting Sighty, that they weren't going to charge? And, you know, this notion, too, that she's now kind of trying to create, and Steptoe, I believe, is doing some of this with her, that, oh, geez, Ryan Londregan should have sat down and explained everything to the Hennepin County Attorney's Office. I can't fathom what defense attorney would ever, in that circumstance, say, oh, yeah, that's a good idea. Go talk to Mary Moriarty. That'll help you. That's a great idea.
Right.
They are always trying to find something, just as she's done here, in order to try to use against you and with respect to that process. Now, the nice thing dealing with somebody as smart as Ryan, he saw that immediately. He saw straight through it, and he knew exactly was. But one of the things that we did do is we said to the BCA, hey, you want a statement from us? We'd like to look at all the body cam. You know what the response was to us? Well, we don't have the body. You got to go ask the State Patrol. I went, really? You don't have the body cam? I mean, they had the body cam. They had the squad videos. They had all that stuff. But they said we had to go talk to the State Patrol, which to me was also just ridiculous. Give that to the officer early on. These are some of the additional things, too, that I've made a list here with respect to the MPPOA to kind of go to the legislature to try to level the playing field on some of these things, that the officer in a critical incident should be able to access his or her own body cam and squad videos relating to the incident immediately. That should not be some sort of, something that is only shared with the prosecutor. For God's sakes, the officers lived through it, so why can't they access that sort of thing?
I agree.
And so this notion, too, that, had he talked, then we never would have brought these charges. I mean, come on. That is just, that's ridiculous. That's absurd. That's nonsense that they're just spinning again in order to try to create their own narrative.
Let me ask you this. She brought up in her press conference, Mary Moriarty, something called the Queen for the Day, or basically where they would give him immunity to tell them what his actions were. Can you explain that?
Thank you. Yes, okay. I would like to explain that. It's called Queen for a Day because it's for a day, okay? With respect to Sighty, he was giving what's referred to as use derivative use immunity, which means that when you testify to us, we can't use the statements against you, and we can't use any of your statements to derive evidence against you in a criminal case. That is the broadest sort of immunity that when you hear somebody on TV got immunity in federal court, they got use derivative use immunity. Okay. That's what that means. Queen for a Day immunity is also referred to as proffer immunity. And all that means is you can come and talk to me, and I can't use the statements against you in my case in chief, but when you testify, I can use all those statements against you to cross-examine you.
And to impeach you.
And to impeach you, exactly. Okay. To contradict you anytime during that testimony. So this idea, oh boy, we're really giving him a benefit, that is not a benefit. And I can tell you in federal court, I can count on my hand the amount of times that I've ever agreed to proffer immunity, and it's only when I have somebody that's so tangential to the underlying target of criminal investigation that I'll permit that. If I know that they are a subject of the target investigation, there's no damn way that I'm going to permit them to just work on proffer immunity. There's not a chance. And frankly, I've had one situation where my client said, I want to do it. I said, find another lawyer. They did find another lawyer, and he got charged.
Okay.
And that's what happens. Joe Freeberg, one of, said this before. If Minnesota had a Mount Rushmore of lawyers, Joe Freeberg's, bust would be on it. Told me when I was a first-year lawyer, the maxim, nobody talks, everybody walks. And it's true. And it's true in cases with honorable prosecutors. But when you've got somebody like Mary Moriarty, there is not a chance that any cop should be going in and giving voluntary statements to her, because it's just going to end up with bad news for you later on.
So throughout the fall and early winter, she convened an investigative grand jury. And can you talk about that? There was some
Yes.
concern that she used the grand jury, but didn't use them for an indictment.
Yes. So in federal court, you have a constitutional guarantee to be indicted by a grand jury. And the government can bring a complaint against you, but then they have a limited amount of time to go to the grand jury and get you indicted. If they miss that time, then the charges are dismissed. In state court, the only what the state is claiming is that the only grand jury that is required is for first-degree murder.
Okay.
They took the position that they could convene a grand jury just to investigate, but not ask the grand jury to charge anybody. I think that that is 100% wrong. And here's why. I cited, I think it was about 4 different Minnesota Supreme Court decisions that talked about that the purpose of the grand jury is twofold: investigate and indict. They talked about how the grand jury is a sword and a shield. It is a sword because it has broad investigatory powers, but it's a shield because it's the citizenry that is standing between the government and a potential criminal defendant and saying when they're going to be charged or not. In this case, they just used the sword. They did not ask the grand jury to indict. They specifically went in and said, no, we're just going to use this to compel testimony against people, when these people, the reason that they weren't talking, is I'm going back to my previous statement, is because I'm not talking to anybody like Mary Moriarty, because I could get charged. I'm a cop. There's no way that their lawyers are not dumb. And so they know what they're doing. The thing that just drives me absolutely nuts, there was a former Hennepin County judge that said, the investigatory grand jury is time honored. Yeah, so is bleeding. We used to bleed people when they had a headache. We used to bleed people when they had some sort of ailment. That doesn't mean that it was necessarily smart, does it? The Supreme Court has said that this is wrong. They said that you are subverting the two processes. There is not one decision that affirms the grand jury's use just to investigate without indicting. And I think that that's exactly what the Hennepin County Attorney's Office knew. I think that they knew that if they went there and asked these citizens to indict, I think that they knew damn well they were going to say no. They're going to look at this and they're going to say, hey, listen, from the time that door opened to the time that Ryan shot the first shot was less than 5 seconds. It's actually 3.5. And I'm going to hold him responsible for murder on this. I mean, I think that they would have just laughed him out of there. I think that, it would have been one of the very first times I think I would have heard abject laughter coming out of a grand jury room.
It is interesting that up until, I don't know the exact date, but 7 to 8 years ago, the county attorney was always using a grand jury on these police use of deadly force cases to to review the case and either indict or submit a no bill. And under Mike Freeman, that changed towards the end of his tenure. He decided he was not going to use the grand jury anymore. Do you feel that it's not consistent that Mary Moriarty was just kind of following that lead from Mike Freeman?
I remember Freeman talking at the time, and there was part of me that respected what he was saying, that, listen, I'm the elected person. The buck stops with me. I'm not going to pass this on to a grand jury. And I get that, from a standpoint of accountability, I can admire that. I think that it's a very dangerous practice when you're dealing with law enforcement. And I think especially in an environment like right now, where you have people that, I mean, like Mary Moriarty was literally running on the idea of holding, quote, and I'm using air quotes here, police accountable,
right.
Which is, a code for I'm gonna charge a cop. You need to have that barrier between the government and a potential criminal defendant, and that's why, frankly, even though there's that maxim that you can indict a ham sandwich. I don't really know. I don't really believe that that's true when you're talking about cases of murder, and when I think that citizens really actually understand the gravity of the situation, and I really believe in the jury system. I think that by and large they get it right. There's certainly some cases where you scratch your head and say, yeah, it's nuts, but I think by and large, I think it was Winston Churchill, kind of said that about democracy. It's the worst system of government, but it's the best we got. I think the jury system's similar to that. And I think using that grand jury and in circumstances, particularly with law enforcement, particularly somebody in Hennepin County, I think it's essential.
So fast forward to January 24th, Mary Moriarty made the announcement and filed charges against your client, Ryan Londregan, for second-degree murder, first-degree assault, and second-degree manslaughter. Talk about that day and what took place shortly thereafter.
My terrific co-counsel, Peter Wold, knows Ms. Moriarty. She's never spoken to me. I've never spoken to her. I don't think I'm going to be on her Christmas list. She called Peter and told him. Peter called me, and my response was, "You got to be effing kidding me," and I didn't say effing. I was shocked. I sat in my chair in my office and looked out the window for an inordinate amount of time, and I literally was shaking. I was so certain that this passage of time cooler heads had prevailed, and that somebody over at the county attorney's office had said, "This is wrong. This is not right. We can't do this." And my God, was I wrong? I mean, and calling Ryan and telling him that was honestly one of the worst days of my career.
I bet
it was to tell somebody that's just doing their job and saving another man's life, and now you're being charged with murder, manslaughter, and assault for it.
Yeah,
and just wrong.
Well, and it all comes in this atmosphere of since 2000, I believe it's 18, maybe 17, until now there have been 8 peace officers charged with some crime related to their use of deadly force. Prior to that, 2017 roughly, in the history of Minnesota, a peace officer had never been charged with a crime. So the pendulum had just swung so far over, and I know for a fact, I was an officer at the time, and I still keep in touch with officers, that atmosphere that they were working in was just so demoralizing, knowing that...
I can't begin to understand how you come to work every day like that.
Right. So the complaint comes out on the 24th. 2 things that I find interesting. Number 1, there was no mention of this critical expert witness. What can you tell us about that?
Yeah, absent. And believe me, that was notable to us too. And we were all speculating that they had talked to a use of force expert and that this person went south on them. But we didn't know. We really had no idea whether or not that was true or not.
Right.
And the next thing that, believe me, when we put together our discovery, I made very sure to say, I want every statement from every use of force expert that you've retained, and put that really up front.
Yep.
And we did very, very detailed discovery requests with respect to the case, and we served that almost immediately.
The second thing that I found interesting, and maybe you can correct me if I'm wrong, but I've never seen in all of the cases I've reviewed online, I've never seen the defense file a notice of defense on day one. The day the complaint came out, Mary Moriarty and the public and the court, we were all aware of what Ryan Londregan's defense was. Can you talk about that decision?
Yeah. Again, I really believed that the charges were not going to be brought. I truly believe that. But I also believe in Sun Tzu and the art of war. And in times of peace, you prepare for war. And so I drafted that up, and I had that ready to go. And I worked on it with Ryan, and I am embarrassed to say, I think it's about 4 pages. I am embarrassed to say how many hours I spent on that, but there were a lot of hours spent on that. And I'll tell you now, and I've said this to anybody publicly, the problem with a lot of high-profile cases, that's one category. Then you have a cop case, which is a different kind of high-profile case. It augments the high profile. It makes it an even bigger deal. It goes national. One of the things that is a problem with those is that if you just take that complaint and then you just go to court, you're letting the state control the narrative of your case. They're going to dominate the headlines with respect to that day, and they are very used to that, and they like that a lot. I said early on to MPPOA and others, ain't going to happen here. We are going to use this, and we're going to counter this as much as we can and as hard as we possibly can. And the reason I did that notice of defense that day is to get out our notice of defense immediately when they were saying that he did something wrong, so everybody knew exactly he was acting here to protect Seide and secondarily himself.
Yep.
And then we also mentioned the grand jury in that as well. And I also quoted Seide and Erickson's written statements in that as well.
So I notice in the notice of defense, you didn't get real detailed on how he felt threatened, but you knew at that time that what his defense would eventually be. And
I wrote in there that he acted first to protect Seide from death or great bodily injury, and secondarily himself from death or great bodily injury. And then I provided those statements from Seide and Erickson. And I'll have you know, and I don't know if you're getting to it, but then during the first hearing, the county attorney's office, the lead prosecutor, who then jettisoned the case, complained that my notice of defense was too detailed.
Too detailed.
Too detailed.
Okay.
Yeah. I mean, listen, to his credit, he saw what I did.
Yeah.
And, he brought a knife to a gunfight.
So a number of things happened throughout the spring, and to the point you were making, you were kind of going on offense on this case, and you filed a huge amount of things in the case. And I remember the judge kind of getting at all of you about quit filing all these things first. Can you talk about what that controversy was all about? And
I honestly, every one of the motions that we filed, I will say to my dying day, was meritorious. Every one of them that we filed was something that the state had not given us in discovery that we were entitled to. I also will absolutely recognize that what I file in my typical cases is more than what judges are normally accustomed to.
Okay, so that's your style.
I do that in every case, but I also believe that my clients are entitled to the best defense humanly possible, and in those motions in particular, and on those that first round, I wrote all of those myself. And I really, truly believed in every one of those, and feel especially the one with Noble, where I feel that we were not only just entitled to the subpoena, but what we didn't get, and what I would love at some point that somebody does the Minnesota Data Practices Act request, is to show all their internal communications regarding Noble, which we did not get. which I believe was wrong. I think that we should have received that. And I think that we made a very compelling case on that. And frankly, I don't think it was ever adequately explained why we didn't get it.
Okay. So let's jump ahead to just the last few weeks or so, maybe last month or so. There's been some unconfirmed reports starting a month or so ago that the governor was, poised to step in and take the case from Moriarty and reassign it, or give it to the attorney general, who would then have to reassign it. Right. When did you first start hearing about that, or were you part of any official discussions about that?
Well, Brian Peters and the MPPOA were really, I have heard now from talking to some other lawyers from other states that they get sort of a half-hearted support from their associations or from their unions. I cannot begin to say how different my experience has been. Brian Peters and Dave Titus, the MPPOA, Dave's the chairman, Brian's the executive director, have been shoulder to shoulder with Ryan and me since day one. And literally everything that I've asked them to do, which some of the stuff is they have not done before and it's unconventional, and they'll go, yeah, okay, if you think it's a good idea, let's do it. They have really been there. And Brian was writing letters to Governor Walz with Imran Ali, the general counsel of the MPPOA, and Stephen Furch as well, writing letters to the governor asking for the case to be reassigned on the basis of the evidence that we had gotten not only from Noble, but then when we started getting declarations from other members of the State Patrol. And we're sending these to the governor. They had done 3 letters and a press release and asking the governor, please do this. It got honestly to a point, Dave, where I was frustrated. And I decided, I've got one of my partners is Matt Pelican, and I knew that he had the email address for the governor's chief of staff, and I asked him for that. And Matt, more than happy to help for any client, and I also knew the general counsel. And I started sending them, and I sent them 2 emails directly. One of them attached the declaration of Chris Erickson, and one of them then, I believe, attached the declaration of Sergeant Johnston. And the last one I said, and on all of these, by the way, we're getting the public statements. The governor's concerned. And I know a lot of people have taken issue with that. He shouldn't have said anything on any of that stuff. I mean, God's sakes, what was the man supposed to say? Mm-hmm. I mean, you got a use of force expert that went south on you. It's now public. He's supposed to say, well, I have no comment. I mean, he's the governor of the state. I mean, he has a right to have an opinion on these things. And were he not concerned on this, I would say that, is there something wrong with his head?
And let me interrupt. The declarations that you're talking about, they're from trainers in the Minnesota State Patrol, and they go directly to the complaint. So the complaint was devoid of any expert witness saying what Londregan did was illegal or wrong, but they alleged that Londregan did not follow his training. And then, lo and behold, throughout the spring, there were 5 different declarations of people that directly trained Londregan or wrote policy for the State Patrol, all swearing that what he did on July 31st was exactly what he was trained to do.
100%.
Yeah.
And these guys deserve to have their names set. There's Major Chris Erickson. There's Lieutenant Wenzel. There is Sergeant Halverson, Sergeant Johnston, and Sergeant Wenzel. These men did these declarations. I should mention, normally in the normal case, I would meet with witnesses. I'll meet with you as a potential witness on a case and try to get you to remember as many good things from my client as I possibly can. I've never met any of these men.
They proactively came
I did not
forward.
write one thing that they wrote. I did not write any of it.
Right.
They had their own lawyers. They worked with their lawyers. I got signed declarations from them. I can tell you that I was extremely happy when I read these declarations, for Ryan. But also with respect to what these guys did, they didn't get authorization from their brass within the State Patrol. They just did it because they knew it was right. And I, as Ryan's lawyer, and as just a human being, I can't thank these gentlemen enough. They are true heroes for what they've done here. And I hope everybody that is listening with respect to any law enforcement officer, when you see these men, express your gratitude to them. Because this is exactly the sort of thing that we need to have. We need to have people stand up for things when it's wrong. These guys did it when nobody was really watching, and a lot of this was more or less kind of negative as against Ryan. And they showed real courage.
It's good to hear and good to note. So tell us about this past week. Was Sunday just completely out of the blue for you, or did you know something was coming?
I got a call from a reporter telling me that they had heard a rumor that the charges were being dismissed. I had picked up the phone. I said to the reporter, is the governor reassigning? And the reporter went, what? And then I said, what are you calling about? And they said, I've heard the charges are being dismissed. And I said, no. And then, again, I've said this before. I said, listen, I don't know why I am surprised. I mean, there have been so many events on this case that have just floored me, and I kind of got numb to it. And that really kind of happened to me next. So my next phone call was to Ryan. And this reporter had spoken to somebody that knew, and I'd known this reporter for a long time, and I trust the reporter. And when I couldn't help but ask Ryan, hey, I got a call. You want to guess what it was? And his first response was, the governor's not reassigning. And I said, well, yeah, that's partly true.
But he was pessimistic about it.
Yeah, but your case is being dismissed.
Oh my gosh.
And he needed me to clarify that a few times, and then within an hour, the Hennepin County Attorney's Office filed the notice of dismissal and copied us to the court. So it was in writing.
So your only communication from Mary Moriarty's office was an email that you were copied in on.
Correct.
And Mr. Wold wasn't contacted.
Correct. I contacted Mr. Wold and told him. Yeah. No. Listen. It's an absence of class. It's an absence of professionalism, and it's 100% consistent with who this person is.
Yeah. So the charges, when she files her order of dismissal, or is that what it would be called?
Yes.
Or, okay.
Yeah. No. Actually, the Attorney General's. When the county attorney just files a notice of dismissal, it's done.
It's done.
It's done.
Can it ever be resurrected?
So, if you're asking me in a law school final exam question, the answer is yes. The only time that you cannot charge somebody twice for a crime is when double jeopardy attaches. That's only when the jury is seated.
Okay.
However, in this notice of dismissal, she wrote that they didn't believe that they could prove this crime beyond a reasonable doubt. So I can use that document in any subsequent prosecution, and that's on a legal basis. And then all of her subsequent statements, I can use those because they're admissions of a party opponent to say how she could not prove this case. So I could use those if she ever charged again. That's kind of the legal side of things. The practical side of things, I mean, with this environment right now, I think if she tried to charge Ryan Londregan right now with jaywalking, I think that there would be pitchforks in the streets. I mean, yeah. I think even Mary Moriarty knows better.
So, in the practical sense, it's done.
Yes.
The state case.
Yes.
We've heard talk of a at least at a request from the Cobb family of the federal government for
Yeah.
a civil rights violation.
Yeah.
What do you know about that?
Yeah, they've written a letter. I mean, the letter contradicts their civil complaint itself, written by the same lawyer. I mean, it literally contradicts it, which we're going to be pointing out in court here soon.
Okay.
And listen, the chances of the U.S. Department of Justice Civil Rights Division or this U.S. Attorney's Office picking up a criminal investigation of Ryan Londregan has better chances than me winning a Powerball tonight.
And then finally, you alluded to a civil case from a civil lawsuit from the Cobb family against, is it against the State Patrol and Ryan Londregan, or who's all
No, it's
named
against
in
Trooper Sidey and Trooper and Ryan.
Okay.
So it's against both of them. We're representing Ryan because the Attorney General has given him an engagement agreement that requires him to relinquish all litigation decisions in favor of the Attorney General, which to me is outrageous. And I don't think that it's permitted by the statute. And I also think that it's unethical. As a lawyer, when I'm representing a client, the client makes the call on when something is going to settle or what an argument should be made. I can make trial decisions. I can make strategy decisions in the moment, but I should be discussing all those with my client. And I certainly can't, just because I think that I'm all that, get to make all the decisions for you, my client. And I think that it's outrageous what the Attorney General office has proposed with respect to Ryan Londregan. And when I saw that, I just said, I'm not going to permit that. I don't care if I'm working on this for free or not. But that case, I really we've already filed our motion to dismiss. I believe under federal law, it has absolutely no legs.
Okay. So you are invested in this case to the end.
I am going to be here until the very end with Ryan Londregan. I've told him and Grace this several times. John's not old enough to understand how horrible this is, but I'm with them for the rest of their lives. And I'm going to be there with whatever happens. One of the things I just discovered today, Colonel Langer, who I tried to get involved with respect to the case.
He was the colonel of the State Patrol at the time of the incident.
Correct.
But has since
And his initial
retired.
press release kept talking about how this was a tragedy and how he was sad for any loss of human life and all this sort of nonsense. I felt that at the time he was more or less kind of putting his finger to the wind to try to see where the political winds were going and he was at that time was thinking that it was going to remain anti-cop. So I think he was trying to kind of be a little bit more on that side than on Ryan's side. But then he resigned in early April, and we kept hearing behind the scenes, "Oh, I'm on your side. I am on your side. And when I'm gone, I'm really going to help." For about a week or so after that, heard nothing. I asked Brian Peters to call him. I asked Eric Nelson, who represented Major Chris Erickson and did that phenomenal declaration for us. I asked him, boy, they're both high up ranked people. Eric could be the person to represent him. He's perfect. He knows the case, could help him. Spoke to Eric, wanted to think about it some more. Then he told Brian, I don't want to be represented by an MPPOA associated lawyer. It's better for me to be not associated with that. I called one of the best attorneys that I know in Minnesota, Anders Folk, used to be the acting U.S. attorney, former Marine. He's working at the Jones Day Law Firm. His hourly rate is I think it's over $1,200 an hour. Anders offered to do it for free. I texted that to Langer. He never reached out to Anders. Instead, he ultimately got somebody at the Attorney General's office that communicated to Peter that didn't want to be involved. I've since found out that he signed the internal affairs complaint against Ryan and just attached the criminal complaint to it, which again comes back to my statement that I said earlier. Just because you as a member of law enforcement are asked to do something doesn't mean that it's right.
Right.
And putting your signature on something like that is wrong. And it's wrong not only because Ryan didn't do anything wrong that night and they did everything right, but it's also wrong from the standpoint of look at this from the organization standpoint and their confidence in working for the Minnesota State Patrol and what's going to happen to me when this happens next. And I think that was just an abject failure of leadership. And when I contrasted or I juxtapose Erickson, Wenzel, Halverson, Johnston, and Morrell on one hand and put Langer on the next, when I meet my maker, I would rather be on the Erickson side.
Talk about Ryan Londregan's future here. What do you anticipate? Is his future in law enforcement? Is he talking about it?
Yeah, he is. He wants to go back. I mean, I represented with my managing partner Jenny Robbins, represented Todd Hoffner, who is the Mankato State football coach, who was charged with child pornography for taking some innocuous pictures of his children that was dismissed for lack of probable cause. And Todd, an arbitrator ordered Todd's job to be back. And everybody encouraged Todd not to go back, and including me. And Todd said, I want to go back. And he's now been in national championships. He's done phenomenally well. He's a great football coach. His wife Mel is equally fantastic. Ryan's a lot like Todd.
Yeah.
And honestly, it's mildly concerning for my own self-worth that I don't think I would. I think at some point I would just say, kind of F them. I think I'm going to go do something else.
Right.
But that's just not who these people are. They want to do the right thing all the time, and they want to go back to something that they've been building and doing well. And that's what Ryan really wants to do. And honestly, I said this before, I'll say it often. If I called 911, the top of the person on my list I want coming to my house is Ryan Londregan. Absolutely, 100%. I heard early on, you could have shot Seide. I had that conversation with Ryan, and Ryan's like, no. And it was U.S. Navy SEAL-like. And I felt it in my bones. If I would have fired, and I'm a bad shot, but let's put that aside. If I would have fired, I could have killed Seide. After talking and knowing Ryan Londregan, I am more certain that he was not going to hurt anybody but Cobb that night than I am that I'm sitting here with you right now. I mean, this guy is about as good of a cop as you're ever going to get. And the idea that he goes back is great, but he's got to get through this internal affairs garbage.
Right. Well, let's wish him luck, and hopefully he makes the decision that turns out best for he and his family, and we wish him Godspeed.
All right, me too. Thank you so much for him.
And thank you so much for the work you did in this and the work you've done to start pushing back against the anti-police narrative.
It has been my sincere pleasure, and it's been my sincere honor representing Ryan Londregan.
Well, with that, thank you for tuning in, and join us again for our next American Experiment podcast. Thank you.
Thank you.